Good afternoon, ladies and gentlemen. Welcome to the Architect's Guide to Managing Risk on Complex Residential Construction Projects webinar, brought to you by AIA Contract Documents. A few administrative items before we get started. You will be receiving the PowerPoint along with the recording of today's session at the conclusion. In addition, this education session is eligible for one AIA learning unit. When you registered for the program, you entered your AIA member number and will be using the number you entered to report your credit within the next 5 business days. So with no further ado, I'd like to introduce my colleague, Susan Van Bell. She is Senior Director of AIA Contract Documents Content at the American Institute of Architects. Susan?
Thank you, Husty, and welcome everyone to our program today. We hope you'll find it informative and enjoy the time you're spending with us. We have the next slide, Husty. There we go. My co-presenter today is Kevin Miller. Kevin's the President and CEO of GSBS Architects. Kevin has been on the Contract Documents Committee for 10 years now. He's a past chair of the committee, and he also headed up the development of the subgroup within the committee that developed many of the documents we'll be discussing today. So we're very fortunate to have Kevin's expertise on this program. This presentation is protected by copyright laws, of course. So we ask you not to reproduce it and present it yourselves. Next slide, please. And as Hasti mentioned, this program is registered for continuing education with the AIA, and you'll be receiving 1 LU. And also, I should just mention that the information we're providing you today is not intended to be legal advice or specific legal advice on any projects you're working on. You would have to contact your own attorney. So, of course, learning objectives, I'm not going to read through these. I assume you know them since you signed up. But basically, we'll be talking about the kinds of risks that are associated with mixed-use, complex residential type projects, and especially talking about condominium construction and the inherent risks there and how to try to mitigate some of those risks. So Kevin will talk a little bit now about the kind of diversity you will see in residential projects.
Well, good afternoon, everyone. Happy to be here. Okay, so there are a broad range, I think, of project variables that fall underneath the umbrella, of residential architecture, design and construction. From the project types ranging, as we all know, from a small single-family home to very complex and very large mixed-use projects that bring together a number of elements. They have a similar diversity of clients, again, from somebody who's never really experienced an architect previously to very sophisticated developers. And the projects are delivered in virtually every kind of delivery model we can imagine, from traditional design, bid, build to self-perform work by developers, everything in between. Next slide, Hosty. So given that great diversity of variables in what you can be encountering in the project type, there are nonetheless some common issues that present risk to designers and also constructors and owners of these projects. But specifically for today's purposes, with the architect's focus, things like owner expectations when you're dealing with a single family home and somebody that doesn't know what to expect of an architect. That's one set of expectations, and that highly sophisticated developer may have a completely different set of expectations. And I think in today's market where residential has reintroduced itself as a hot market for design and construction, a lot of people are entering it, both from the design side and from the owner side. You can deal with owners that may not know what to expect even though they appear to be sophisticated. There are issues of scope creep and budget. That's not unique to residential construction by any means, but it's very personal a lot of times when you're dealing with someone's home. Copyright, the protection of the intellectual property is a big deal in residential because a lot of this product looks very similar in plan, and so it's very important to protect the copyright, the intellectual property of the architect and the designer. And then there are specific jurisdictional requirements, whether that's in the realm of single-family residential, where there are specific laws that protect home buyers, or we'll talk a little bit later about condominiums, and the laws that pertain to condominiums vary state by state, jurisdiction to jurisdiction. So there are a lot of potential pitfalls, but they cross all of the project types that we might encounter doing this kind of design.
So I'm just going to briefly address single-family residential construction. That's not the focus of this program, but we have previously talked about it a little more in this program, and then we sent out last fall a survey to a number of residential practitioners, and based on their responses, we really found that the needs of single-family home practitioners and custom residential are different than the people working on more complex projects, and so we actually decided to develop two separate programs talking about the different types of residential. But if you signed up for this webinar and your focus is more on single-family residential, the list of documents you see on the screen now are the ones that would be suited for your use on that. The B105 and the B104 are really more geared towards small and very straightforward projects, whereas the B101, which is sort of our flagship owner-architect agreement, is really the one that we have found people are using quite a bit in residential. And the documents we're going to talk about today are really built on B101. You might also note that all of these documents have 2017 dates on them. They're all in our A201 family that was updated and published in the spring of 2017. And if you use these documents or you're interested in using them, we have a lot of resources available on our website that help you to see and understand the changes that were made in 2017. Next slide, please. So B101, just very quickly go over the basics of it, because as I said, it is our flagship agreement and it's sort of the chassis on which the other documents we'll be talking about today are based. But the ones we're addressing more specifically today have been better tailored towards complex types of projects. But B101, traditional 5 phases of service. You have schematic, design, development, construction documents, procurement, and construction. It uses A201 as its general conditions, and the architect provides the cost estimating and scheduling as part of its basic services. Next slide, please. So now we'll move on to the heart of today's program, which is the residential or mixed use. And these are the documents we'll be focusing on: B109 2010, B509 2010, and A145 2015. B101 is the owner-architect agreement for multifamily mixed use, multifamily residential or mixed use. Now, the B509 is called Guide for Supplementary Conditions to B109 for use on condominium projects. We'll go into more detail on that, but basically B109 was developed for multifamily residential or mixed use, which is not condominium construction. And then B509 has model language that can be used to modify B109 to make it suitable for condominium use. We'll be referring to that through this program probably as the condo guide, but as you can see in the title, it is actually a supplementary conditions document. And then the A145 is a document we developed recently, 2015, for 1 or 2 family residential projects using the design-build delivery method. And just also a quick note on 109 and 509, you'll see they have 2010 dates. They are in the A201 family, which is typically revised every 10 years. When we last updated the A201 family in 2007, we weren't publishing these 2 documents. And at that time, we decided we needed to publish documents that were more specific for these types of projects. And so we developed these documents, published them in 2010. And of course, if you think back to 2010, you know what had happened right when we published these documents, which was the recession. And most of this kind of construction came to a screeching halt at that time. And so these documents didn't really get a lot of attention. A lot of people don't even know we published them, but the last few years, fortunately, with the resurgence in this type of construction, people have gotten more interested in them. Now, they will be due to be looked at for an update in a couple of years, but I will say we did look at the condo guide a couple of years ago and made a few minor updates to it, but we were pleased to see that, generally speaking, it was still as current in terms of practice as it had been when we published it. And now Kevin will take us into discussing some of these documents.
Okay, so let's go ahead to the next slide, Hosti. Let's talk about the specific issues of the complex multifamily and mixed-use kinds of projects. First and foremost, we think are the developer expectations, and I mentioned earlier that we have a new emerging market in housing. There's a lot of this product being built, designed and constructed, and I think the sophistication of the clients can vary pretty greatly. And a lot of people are saying, I think there's an opportunity to make money there. I'm going to get into that business without really a thorough understanding of what it means from a developer perspective. So setting expectations from my perspective is one of the key aspects of managing risk on any architectural project, but I think it's especially important in the complex residential marketplace, and in particular when you are dealing with clients who might be new to that space. To the extent that the projects end up being condominiums, and while at least in my market right now it appears this is all sort of rental stuff that is being absorbed, at some point condos will also make a comeback, and many developers are saying things like, well, we're going to start out with rental, but we'll turn it into condos maybe if things go well. So you're dealing with individual homeowners in that situation, and a whole bunch of them, and there are a lot of potential pitfalls with that. Homeowner associations, once you cross that condominium threshold, we'll talk a little bit about the risks involved with them. Usually those are folks that aren't well qualified for the job that they end up being elected to. They don't want to spend the money. They don't want to be the person that assessed the condominium a big dollar amount to do something like repair a roof that needs regular repairs, and so they do not manage that responsibility well. And then regular maintenance of these kinds of projects, a lot of people living all in one building leads to a lot of maintenance, and that presents potential risk to the designers of the projects.
So B109, I'm sorry, shifting gears here. As we mentioned, is the owner-architect agreement for services for multifamily residential or mixed-use residential projects. B109 was built with high-density multifamily residential projects in mind, and projects that include occupancy as a component of the program. Now, B109 is part of the A201 family of documents, which is our family of documents that uses A201 as the general conditions, and it's for a design, bid, build type of project. So if you were entering into a B109 to use on a project, you would use one of the A201 family owner contractor agreements, and then you would use A201 as the general conditions. We built B109 on B103, which was built on B101, and I'm sorry for throwing all these numbers at you. B101 is our standard owner-architect agreement. B103 is for complex projects, and it contains certain revisions to B101 that are, better suited to complex projects. So one of the things is that the owner provides cost estimating and scheduling consultants in B103, and you can use delivery systems, fast track delivery, and that sort of thing. So those are all assumptions already built into B103, which we thought were pretty much the kinds of assumptions you would want built into a contract that you were going to use for this type of multifamily complex project. So, but in addition to what's already in B103, B109 was tailored to address more specific issues. So there are other terms and conditions that have been added. One of them, as we've mentioned, it specifically says it won't be used for condominium projects unless the parties agree on that. And then we have the B509 to address those issues. So as I already mentioned a little bit, the B103 was the model for B109 because it was already geared towards complex projects. It already included some of the more specialized owner consultants that were not part of the architect's scope here. It could be used for fast track delivery, and it's just the multifamily requires more robust terms than were included in the B103.
The two key differences that separate B103 and B109 are a new services category for pre-design. When we went out to the market and asked practitioners what characterized these large multi-use, multifamily kinds of projects and differentiated them from other things that they might do, they described the need to conduct conduct site analysis and pre-planning kinds of activities that heretofore had gone uncompensated, sort of were being done but weren't being represented in the contract. And in a B103 or B101 environment, you can provide those services, but they are additional or supplemental services, not part of the basic agreement. And that, anytime you try to negotiate with an owner about adding some additional services and the fee that would be associated with it, that's always a bit of a struggle. So we thought that adding a separate section that described all the things that were really necessary to complete this kind of work would really help architects get paid appropriately for what they were providing. The other unique characteristic was additional owner consultants are added to the list of things that an owner might provide. So Susan mentioned cost estimating and scheduling are unique to B103. They're carried over to B109. We also added envelope consultants. You could add acoustical consultants. There are a number of consultants we can put to the owner, and envelope being the one that always jumps to my mind as particularly relevant and important to make sure that that's done right and to make that an obligation of the owner so that they do not discount the recommendations that their consultant provides. going to elaborate a little bit on the requirements during that pre-design phase. So it shifted all of the, this created great chaos amongst the document committee, because Article 3 is traditionally the architect services, and we pushed that to Article 4, which pushed additional services to Article 5, and you can imagine just how much consternation that might result in, but we're living with it. And the important thing was to create a specific article for the pre-design services to review those studies, the specific laws and codes and regulations that pertain to residential things like HUD, Fair Housing Act, and those kinds of things, and then to attend the preliminary meetings with the agencies, the authorities having jurisdiction, that are necessary to ensure that the project can go forward. Really stuff that happens before a developer is willing to pull the trigger on the project and commit himself or herself to your big fee and the entire enchilada. And by creating a separate article, we create a separate compensation line, and that allows you as a practitioner to say, look, if the thing dies at the end of Article 3, then so be it. And this gives us a place to terminate the contract conveniently, but I'm going to have to do all these things, and I should be paid for doing them. And that was really our intent. Some other issues related to those pre-design services, traffic studies, geotechnical studies. Go ahead and show the next slides, Hosty. Revisions that are necessary to accommodate what a authority having jurisdiction, my mouth's not working today, authority having jurisdiction might require of the project to move it forward, some preliminary studies about unit mix and size, and basically supporting an owner's development of the pro forma and convincing everybody that this is a good idea to move forward thing. But again, these are all things that take time and effort and shouldn't go uncompensated in the architect's world. And so we created a separate compensation section for those pre-design services. And if you terminate the project, so be it. As I mentioned, there are two separate pieces in Article 12 now. One is for the pre-design. The second is for basic services. And then if you're familiar with AIA agreements, there's the compensation for additional or supplemental services, and it goes on like that. But it's unique in this regard.
And as Kevin mentioned earlier, some of the other unique provisions that we've included in B109 have to do with the owner consultants. There's an initial information section in B109, as there is in B103, and now there is in B101 2017. And in the B109 initial information section, there's a fill point for the owner consultants that are required, that the AIA has required the owner to provide in all the owner architect agreements, the geotech, the land surveyor, and that sort of thing. But so we've also listed in this document the building envelope consultant as a consultant that's required to be provided by the owner. And that's because in these types of projects, as I'm sure many of you know, that is, water intrusion is a big issue, and a lot of the cases that end up being litigated have to do with water intrusion issues. And so we felt that it was important to add that as a requirement in this document. And then again, in the initial information section in the owner consultants, there's a fill point for other, and in a parenthetical in that fill point, we list other owner consultants, for example, and then environmental acoustic, environmental impact, traffic, zoning, land use, accessibility. Those are all mentioned in that parenthetical just to flag them. They're not necessarily consultants that would be required in every project, but they're kind of flagged so that people see that, and then maybe that would start a conversation about whether you need them or not. And then if so, that's where you would put them in the document. Next slide, please, Husty. So we mentioned already briefly that B109 is specifically not geared towards condo construction. Let me rephrase that a little bit. Everything we've said about B109 so far and everything that's in it is, you know, you use the document. So for example, if you're working on a condo, the building envelope consultant and those kinds of things we were talking about would still apply. But because there's much more risk involved in condominium construction, we don't want people to use B109 as written. We want them to make modifications that help to mitigate the risks. And so the section 2.3 in B109 says, unless otherwise indicated in the initial information, the owner has represented that the project shall not include a residential condominium. The architect shall provide services based on the owner's representation of the intended usage and ownership of the project. So now here's where we shift into talking about condominium construction, and you really have to shift your thinking about that in terms of different risks and enhanced risks. And so, you know, when you have different risks and enhanced risks, we want to make sure that the owner tells you that's what you're going into. If you don't know that, obviously, you may not, you know, develop your scope and your compensation and other aspects of the agreement appropriately, and then that could subject you to a lot more potential downside once the project becomes a condo and you were not aware of that.
So let's shift gears and talk about the risk of condominium construction. As Susan mentioned, I think I did as well. When we started working on these documents in 2009, there was a tremendous demand in the industry. A number of sources were saying to the documents committee, help protect specifically architects, but in reality, the risks that condominiums present pertain to the constructors and really the developers of them as well, against those risks, because the implications are untenable. For those of you that have or do work in this market, you know that your liability insurer is not very excited about it. Quite often they put limitations on how many projects you can do, or the fee dollar volume as a percentage of your total fees that can be attributable to condominium projects. And you know, if you ask your attorney, if you were to ask, if Susan were your attorney and you were to ask her, should I do condominium projects, you know, they'd probably advise you to run away from them. That being said, people are very successful. Some of our colleagues on the documents committee do this work all the time. I think it is financially rewarding. I think the projects are quite interesting and exciting. And so the key is to figure out how to manage the risk. And that's what we attempted to do in drafting the guide. And you say, well, why did you do a guide and not a contract? And the answer is because the risks presented by condominiums don't stem from the parties that are involved in the contract. Generally speaking, you don't get sued by the developer that you executed your owner-architect agreement with, and the builder doesn't get sued by the developer for some kind of breach or negligent activity. It's the homeowners that downstream move into these things and then discover, or have discovered for them by predatory law firms, defects or alleged defects in the design or construction, and they want you to pay for them. And the protections in your owner-architect agreement don't protect you from that direction. You don't have a contract with those eventual homeowners, and so anything that gets written into your owner-architect agreement doesn't really help you when that lawsuit comes along. And so we backed up and said, well, how can we help the industry in this marketplace? figure out how to manage these risks, and a guide that identified the kinds of things that will protect against the eventual claims are the best protections against those lawsuits. Did I cover everything on this slide? The insurance coverage is a big deal. There are a number of terms associated with condominium construction that are unique. I mentioned the jurisdictional implications. We can add additional services to our portfolio of things that we're going to do that can help protect us. I'll talk about some of those things in a second. We can add some things to the developer, the owner's responsibility, that will also protect all of the parties. And you can try to get a limitation of liability, and we'll talk about that at the end as well. It's not as great a premise as it is with other contracts for the reasons I outlined previously. And all of these things are things that are typically not, at issue in a normal AIA agreement.
Moving on to B509 then, which is the guide for how to modify B109 to use it when you have a project involving condominium construction. As I mentioned, we updated the guide a couple of years ago and covered most of what's on this slide, but let me also mention where you can get B509. It's a document that's available for free on our website. We'll show you that at the end of the program too. But you can basically you can copy and paste the model language that's provided in B509 into your B109 template to make those modifications. So we've tried to make it as easy to use as we can. So as Kevin mentioned, the whole structure of a condominium project is different than your standard project where, you have your owner-architect agreement, and any, disputes that arise are going to likely be between you and the owner and that sort of thing. Here, you really have to think about the fact that there are the downstream unit owners in a condominium project, and that's where it becomes complicated in terms of risk management. And so there's a whole set of terms involved here that help to define the condominium. When we added these terms to B509, and one of the things we learned is that, these terms are unique to these kinds of projects, and some of them may be different even jurisdiction to jurisdiction because, for example, the condominium declaration is a document that is recorded in accordance with the requirements of the jurisdiction where the project is located. And that establishes the condominium as a legal entity in that jurisdiction. And so, the requirements may differ from jurisdiction to jurisdiction. But we defined the terms and included that kind of information so that you would know that. But the examples, the definitions we provide are really examples of what you need to look at. But for example, as I mentioned, the condominium declaration, that is a recorded instrument in the jurisdiction. The condominium bylaws are the bylaws that are recorded with a condominium declaration that govern the administration and operation of the homeowners association. And so these are important documents to think about when you go into these kinds of projects. In addition to negotiating your owner-architect agreement, you can try to negotiate with the developer certain provisions to be included in the condominium declaration or the condominium bylaws that would help to mitigate risks going forward. And we will talk about some of those provisions, but the important thing is you really have to kind of expand your thinking here, and you can't just think in terms of negotiating your owner-architect agreement. You have to be aware of these other documents that govern the condominium and think about if there are any ways that you can, try to have terms included in those documents that would help going forward. And as Kevin mentioned, the risks aren't only for the architect, they're also for the contractor. And so some of these provisions we'll talk about will also help with, risk for the contractor in these kinds of projects.
Yeah, I think that's an important point, and really even also for the developer, right? A reputable developer trying to do a good condominium project is at much risk as everybody else in the process, and so really it's a team effort to try to protect everybody from downstream lawsuits that really have no basis. We're not talking about real negligence or real flaws in the construction, but there are any number of reports of law firms that solicit condo owners associations and say, we'll find the defects in your building and we'll get somebody to pay for them, and that's just not appropriate, I don't think. So anyway, let's talk
Kevin,
about.
I'm sorry, before you move on.
Yeah.
Just, another way that you need to frame your thinking about condos and why the risk is so great, and certainly you would want to talk with your insurance advisor as well when you're trying to get into these types of projects. But, the potential for the damages is so huge because you have multiple units and you have multiple unit owners. And so that's damages multiplied. So it's not like when you have an agreement with, a single homeowner or, whatever in a project, you have an agreement with a single owner. Here you're going to have the agreement with the developer, but then there are all of the unit owners. And, if there's a failure of the roof and there's a special assessment made and all of the unit owners have to contribute to a special assessment, they all want their money back. Or, if there's a defect found in one unit, but it's repeated in the other units, that all just multiplies. And so that's, what a lot of the risk management we'll be talking about will go to helping to mitigate here.
So what can we do to protect ourselves in that owner-architect agreement? There are a number of suggestions in B509. We've pulled out the top list for us, at least. We think these are probably the most effective, but I'd encourage you to download that document if you're practicing in this area and take a look at all of the options. A specific obligation not to reduce the architect's services without the architect's consent. It was pretty common when the market was really robust in the condominium construction to sign up for a full services agreement, and once you get to the end of CDs, terminate for convenience, which the contract generally allows you to do. And we all know, I think, that construction administration and the activities that we undertake in that phase of the work, when they're not required in your jurisdiction to actually be provided, and in some they are our best protection against claims. You're there, you can see it, you see the work go in, you see the shortcuts or you see the flaws if there are some, and you're able to remedy them before they become extraordinarily expensive to do so. Maintenance manuals I'm going to talk about in detail in a second, so I'll skip that one. Susan mentioned the development of the condominium plat, putting into the requirements that the homeowners association has to live with, clauses that pertain to how they go about funding their maintenance budget, so that the things that usually result in these claims, just not having adequate money to fix them, not that they wouldn't fix them, but that nobody wants to pony it up, are built into the homeowners association fees, those kinds of things. And then additional visits post-occupancy, so you have an opportunity to see how the building is performing, and again, nip these things in the bud. I was involved as an expert witness in a case where there were like 25 separate buildings, all of which were developing mold due to moisture penetration, And the thing went on for years before it got to anybody's attention where they tried to fix it. And by that point, the damages and the remedies were much more costly than had they been if you'd have showed up and said, hey, I can see that water's getting behind that detail. We need to do something about that. And then lastly, in this slide, additional construction site presence. It's one thing to be there at a frequency commensurate to the progress of the construction, but maybe it would be in everybody's best interest. And remember, contractors, developers, and architects are all in the same bucket here. So wouldn't it be better for all of us if we had somebody on site full time to watch these things get installed and make sure that they're done properly? I said I'd talk about maintenance manuals. We think this is probably the most important thing you can do, is to include language in your contract, either providing an obligation for the architect to provide a building maintenance manual or obligating the owner to do the same. And then that maintenance manual is turned over to the homeowners association. It is the simple. What our research indicated is it's the simple maintenance stuff left unattended that results in these big claims. It starts out as a little thing, but the homeowners associations don't want to assess their homeowners. They just let these things go. And again, you're talking in many cases in these condominium buildings about very large, very complex, modern buildings, and homeowners associations are run by a group of people who bought a 1,000-square-foot condominium. They don't know what it takes to maintain a modern building, with a rain screen and a single ply roof. These are all things that are alien to their thinking. And so making sure that a maintenance manual is created and that it is a part of what the homeowners association has to incorporate into its thinking is a very important protection. We also have some language in B509 that pertains to the owner's obligations that will also manage that risk. In the past, it was pretty common to encounter developers who would hire contractors that didn't necessarily understand the risks presented by condominium construction. Might have been the first project they'd ever built of this type. And that's just a very dangerous thing for everybody involved to have inexperienced and inappropriately qualified folks working on the construction of these projects. It might cost a few dollars more, but it's going to protect everybody in the long run if you get a contractor that knows what they're doing. So obligating the owner to provide information about the contractor, either that they intend to hire or once they are hired, is a good protection, because you can say, well, you know what, I don't think that's a good guy. We can go on record that that's going to create risks for us and protect ourselves. Also, there are issues of insurance, specifically cutting corners on the general liability insurance, mold exclusions, and there actually are condominium exclusions and EFIS exclusions and all kinds of very specific riders that can be in policies that will cut out insurance that we would otherwise reasonably expect to have been included in the owner's and contractor's agreement. We also suggest language related to the condominium declaration and bylaws, the maintenance manuals, and then mandating that a repair budget be funded. Mandating that there be an early notice of defects. Again, these things quite often happen, but then nobody wants to deal with them. And if we don't get notice early that there's a problem, we see a little leak, but we don't think it's much of a thing in our building, you go out and take a look at it and realize that if it keeps going, it's going to lead to $1 million problem, but we can nip it in the bud. So obligating homeowners associations to notify early of defects and thereby taking away the claim if they do not is a good protection. And then the last one, indemnification against systems or products that get substituted, right? So this, we all encounter this in practice. You very carefully research what you think is the right building envelope system, and lo and behold, something else gets installed through the magic of value engineering or whatever. And if they do that, specific language can be inserted in the contract that indemnifies you from that substitution. Now, again, homeowners are going to come along and sue you, and they're going to sue everybody in existence. If it's a developer that's likely to do that kind of a thing, they're likely not to exist. They will have folded up their tents and disappeared as soon as all the condominiums have sold. And it won't be easy to leverage that indemnification because you can't get the owner to step in front of you, but it doesn't hurt, and it perhaps gives pause to an owner before they decide to do that without having a conversation with you about it.
And I just want to add on this, you don't have to go back to the slide, Husky, but just on the point Kevin was talking about with the early notice of defects, it's really important for you to talk with your insurance advisor and your attorney when you engage in a condo project in a specific jurisdiction, because there are statutes geared towards these as well. And one of them that many states have is called a right to cure statute. And that requires typically that the homeowners association provide the architect and or the contractor with notice and an opportunity to cure defects before they file a lawsuit. And so you certainly would want to know if your jurisdiction has that kind of a statute, because you know, it is helpful and it helps to govern the process if there are any defects found post-construction. With regard to limitation of liability, this language in B509 is the same as what we have in our supplementary conditions document for our other owner architect agreements, which is B503, because we don't include a standard limitation of liability provision in our owner architect agreements. It's an area of the law that's developing, and in some jurisdictions, it's not favored and it's not enforced. And so that's why we don't make it a standard provision. But we do provide the model language, and it is something you'd want to consider in this type of a project. You do have to keep in mind it doesn't protect you against third-party claims. So it doesn't entirely limit your exposure, but there's generally two ways that a limitation of liability provision might be structured. One is to limit your liability to a lump sum amount, or the other is to limit it to the available insurance proceeds. So, you know, that's something you definitely want to keep in mind. And again, certainly talk with your own attorney about that in terms of where the state of the law is in your jurisdiction and how best to structure your limitation of liability provision.
The B509 is pretty broad. We don't just cover the risks of you know, that first construction of that big building. We also discovered a fair number of risks involved in the remodeling and renovation, for example, of a condominium within an existing building, and so there's language in there to protect you against the unforeseen conditions you might discover doing that. And there's also some clarification of responsibilities if you're doing that kind of a project, about the owners providing you the information and indemnification if it turns out not to be right, so that the kinds of things you can sort of get yourself into just remodeling in a building that's owned by 100 people might present. Lastly, we wanted to talk about the problem of advertising in condominium construction. One of the big risks is in the presentation of the product to the potential buyers, and I'm sure you all see this. You see these projects advertised as luxury condominiums, the finest, you know, living in all of wherever it is you are. And those unrealistic marketing claims are a real problem when these cases develop, because the owner says, I expected a luxury, and yet I can hear somebody walking in their high heels above me. Is that luxury? And so we have some model language in B509, talks about review of the owner's marketing materials before they are released to the public, and gives you an opportunity to object to that material if you think it's not characteristic of the kind of project that is actually being built, and protect yourselves against that as well.
Okay, so having asked you to shift gears and think completely differently about condo construction, we're now going to ask you to shift gears again and think about design build. So let me just quick overview of design build to help you with your gear shifting. Of course, it's a model where the owner enters into one contract with the design builder to design and build the project. And so, you know, in the typical design bid build project, the owner's going to have a contract with the architect and a contract with the contractor or constructor. Here, the owner has a single contract with the design builder who performs all of the services. And that's part of the benefit for the owner. They only have one contract, they only have one person, you know, one entity that they're dealing with. And the design builder is on from the beginning of the project inception. Now, the AIA's standard design build family of documents, which was last updated in 2014, is really geared toward commercial construction. The documents are long and they're complicated, and there's lots of forms and exhibits, which, I mean, it's a great set of documents if you're going into commercial construction, but really would be difficult and cumbersome to use in residential construction, particularly if you're dealing with a homeowner and you're trying to use these voluminous design build contracts. And so this diagram just gives you an idea of, you know, what you're getting into with the standard design build document family, which is multiple contracts between multiple entities. I will mention, though, if you are doing this kind of work, our design build family is structured so that the owner enters into the design build contract using A141, and then the design builder can do everything, or the design builder could enter into a separate contract with the contractor or into a separate agreement with the architect, one, both, or neither. And so this family is very flexible. It's just geared towards a different type of project.
And that whole conversation, in the last maybe 5 or 6 years, there have been a couple of presentations made at convention by professionals who have built really nice little practices, being their own design builder of their single family or maybe small size multifamily projects. And I've seen a couple of these presentations. The folks that have done this promoted on the basis that they have great control of the end product. They interface with their owner from start to finish. They benefit not only from the design process and the fees from the design, but then they also act as the constructor, and it's sort of that ultimate act of master builder, if you will. And we developed A145, which is a residential design build document designed to serve that kind of a client. It's a much simpler model to go by. Go ahead and go to the next slide, Hosty. These are the key benefits. Specifically spent a couple of years working on it, trying to address residential design build, really departed from the design build model that Susan just outlined. It's really written as if the architect is the design builder. You could do something differently. You could have a partner that did the building side of it, but this is really architect-led design build. We call it a short form at only 15 pages. I guess that's a testimony to the size of our other documents. And it really only has one attachment. That's the design build amendment that is executed when we all agree that's the project we want to build and here's how much it's going to cost. The process is simplified and a little different from traditional design build. You sit down with the owner and you spell out the initial information. I'm looking to build a house that needs 5 bedrooms and 3 bathrooms, and I'm thinking I have about this much money to spend on it. It's really intended that the owner and the design builder, which in our minds is an architect, sit down and they just gather up this information before the architect begins the design. And the owner signs off on that criteria, and the architect goes back to his studio and designs a home. And once he's got the design the way he thinks he likes it and the owner likes it, they put a price to it, and the design build amendment will set the contract sum. It's important in using this document to think about going down this path, which I think is a really interesting path, to recognize, however, that residential construction is really regulated from jurisdiction to jurisdiction. State to state have different requirements. Things like lien rights, warranties, all of these things vary. And so, you know, Susan alluded to this earlier. AIA documents in general, we try to write language that is applicable across the country. And in this instance, it's just impossible to capture the variation of all 50 states. And so we have fill points that allow you to capture the unique characteristics of your particular jurisdiction. And it's important, if you go into this kind of a business, that you do your homework, consult your attorneys, and make sure you understand those specific jurisdictional requirements before you do it.
Yeah, I would just mention on that, on the jurisdictional requirements, I mean, some jurisdictions even have specific forms in residential construction because they view it as sort of a consumer protection area as well. And so some of them have specific forms providing different types of notice that have to be given to homeowners, and those have to be attached to your agreement. So you really want to make sure, as Kevin said, that you've done your homework and include everything that needs to be included in that type of project. So just very quickly, we have a few other residential documents in case any of you are doing this type of work and don't know about these. B107 is an agreement between design builder and architect for prototypes for a single-family residential project. This is basically for, you know, model type housing that a developer is going to reuse. The architect pretty much provides a permit set of documents and has very limited CA services. The client is assumed to be a very sophisticated entity that can take those documents and, you know, perform the construction. And of course, there are some variations in things like copyrights and some other areas in that document. B108 is an agreement between the owner and architect for a federally funded or federally insured project. We developed this with the assistance of HUD and the USDA. The HUD asks that this document be used in construction under their FHA loan program. The USDA uses it in their rural development program, and it, you know, includes the types of provisions that those agencies want to see included in projects using their funding. So they're tailored for that. And then we do have a guide to AIA contract documents for small projects, which provides information on some of the documents we've talked about today. It's really the ones that are geared towards smaller residential projects, some of the scope of services documents that we have, and some other general information for residential practitioners on why it's important to use a contract, what the basic elements are, and that sort of thing. And that guide is also available for free on our website if you're interested in that, or know anyone who might be interested in that. It's a good education tool. So contact and resources. Next slide, please. Here's a screenshot of the B509, the condo guide we've been talking about. And as I mentioned earlier, that's a free download. And, I would suggest if you're even interested in going into condominium construction, you could download this and read it. It's not just to use to modify B109, it's also a very good education guide. It talks about all of the kinds of risks that Kevin and I have discussed today and more, because we've done it at a very high level. The guide goes into it in more detail, and it would just be a great way for you to educate yourself going into this type of project. And then contact information, we have a Hospi Learn page where you'll see a lot of material and other webinars that are available as well. Questions about our online service, our software, or ACD5, you can address to our Docs Tech Support folks. And then content questions, you can address to docinfo. We can't answer legal questions for you, but a lot of the docinfo questions are things like, do you publish a document for a certain type of project, or, sometimes folks unfortunately will be involved in a claim or a dispute and want to know, information from us that might be helpful. And while we can go to give you legal information, a lot of times it's a matter of knowing what contract you used and pointing you to the provision that addresses it. Understandably, disputes may arise several years after you've signed your agreement, and you're just not remembering the content of the agreement. So we can often point you to the correct provision, and that often comes up in terms of copyrights. So we're happy to hear from you when you have questions about content as well. So we hope this webinar has been informative for you, and I don't know if we have time for questions, Husty. I think we're running a couple minutes over here. So thank you everyone for attending.
So, and thank you, Susan and Kevin, for that informative presentation. I do want to just remind all attendees that you will receive the PowerPoint along with the recording of today's program by tomorrow. You'll also get your credit reported in the next 5 business days. So you did report your AIA member number when you registered. So we'll use that information to report your credit directly to the AIA. So with that, I want to thank our presenters today, and also for our attendees for taking the time to listen in on today's webinar. Have a great day.